Hello, and welcome to the Information Governance, Health Records and Data Security Annual Update. This course is for staff members who don't regularly access personal identifiable data as part of their job. This means that you don't regularly work with patients, for instance like a nurse would. However, you may be involved in moving patients like a porter. It means you don't have substantial access to patient information. However, under some circumstances, you may receive data that tells you to go and pick up certain patients in the same ward for a certain test. It also means you don't have access to personal files of employees, but you may find confidential information where it should not be placed. Here you can see the stated outcomes of this course. But basically, what we need you to do is come away from the session with a greater awareness of personal data, how we protect that personal data while it's in use, how we store the data, and how we control who should access it. This session is not about being an expert, it is about understanding the basic principles and also understanding where to go for help. So what is information governance? Information governance is how we look after information. How do we make sure that it's taken care of whilst being processed? By process, we mean being created, being copied, being printed, being filed, and being destroyed. Information governance is about a set of rules that determine how we should behave with that data, whether it be on the computer, on a whiteboard, or on paper. Information governance is your responsibility, it is my responsibility, and it is everybody's responsibility. Here are what we class as the main responsibilities. Before we start, just remember that confidentiality can be in relation to either a patient or staff data. Our responsibilities summed up would be processing information following the data protection laws and respecting the rights of people within the law, making sure information is accurate. There is no point in having a health record that is full of the wrong data. This would be both a clinical and an information governance risk. Making sure the data is secure. Making sure you follow good standards of record management. That's just making sure that whether the personal data is on paper or in a computer, things are put into what we can call a logical filing system. This just really means that you can find the right data in the right place with minimum effort. And lastly, as it states on the slide, complying with freedom of information requirements, which will be covered later on. Here are a couple of examples. Both examples are equally important, but the one thing to take away, which will be mentioned a little later, is that in terms of data protection, you can now be personally fined for breaking the law. Example 1. In an incident when computer drives that formerly belonged to the NHS were sold to the public through an auction website, buyers found that personal information of over 3,000 patients and staff were still saved on the drive, as the trust had failed to have the drive securely destroyed. It didn't have robust contracts in place, and the NHS was fined £3,225,000 over the incident. That's £3,225 not spent on caring for patients. Example 2. Incidents where patients' data or records are abandoned in public areas, for example in trolleys on corridors, in wheelchairs, or even in locked part vehicles, can result in the breaching of patients' confidentiality. Lost or stolen information impacts on the care of patients, and if those records aren't available when needed, the missing vital information can cause harm to these patients. Information needs to be kept securely and supervised at all times. In this session, we will look at the rules that can help you to handle information securely and effectively. Those slides detail some things that if they were to happen to you, you would be concerned about how your data is being used. Your file with your diagnosis is being kept in an open area that can be accessed by anybody walking into the ward. Someone has taken the information about you that we've printed wrongly out of the PC and just thrown it in the bin. We have mixed your date of birth with that of your father, who has the same name as you, and consequently confidential data about you could be received by your father. Worse still, you could end up receiving the treatment that your father should have. As the slide states, these incidents have happened within the NHS. If we all follow good information governance principles and practices, this should not happen. We split types of information into the following groups: confidential, personal, sensitive or special data, depersonalized, anonymized, and corporate information. We will now go into a bit more detail on each. Personal information is very easy. That's information about you that allows you to be identified either directly as part of the data or by using another piece of data. This data is considered to be confidential in most circumstances. Sensitive or special category data is information about you that concerns your race or ethnic origin, political opinions, religious or philosophical beliefs, trade union memberships, genetic or biometric data, health, sexual lifestyle and orientation. This is also considered confidential data, but one could say it is something considered to be slightly more confidential than confidential data. Depersonalized data is where your identification has been removed or changed. This can be done by perhaps using your initial as a year of birth rather than the details. There is still a slight potential that this could be or become recognizable data, so it should always be treated in the same way as confidential data. Anonymized data is where everything that points to you as an individual has been removed. In this case, the data is considered to be safe. Let's look at some laws. Firstly, the biggest law, the Data Protection Act of 2018, which includes GDP and all general data protection regulations. The Freedom of Information Act is to do with all data that isn't personal. Health and Social Care Act talks about how we should deal with health and social care data, particularly how we should be working with someone with special category information that is confidential. The common law duty of confidence is the most misinterpreted law because it isn't a law, it is an obligation. A prime example is a confidence that exists between a patient and a doctor that cannot be disclosed without the correct legal authority or justification. This is why preparing to provide information in case of inquiry must be dealt with after taking advice. NHS Code of Practice, which includes professional codes of practice that doctors, nurses and physios must follow. There are many more laws and you don't need to know them all. What you do need to know is the spirit of those laws and how to protect the confidential information you may come across. Not only do we have an Information Commissioner's Office, we also have a National Data Guardian that has their own data security standards that cover people, processes and technology. For people, it's pretty easy to look around. There are people. Processes and how we deal with data and technology is obviously the systems we use to hold or display data. Following GDPR, you have extended rights now. Listed here are some of them. Depending on certain situations, it's always worthwhile knowing all of them just in case. You have the right to be informed if your personal data is being used, so if you are using your data for research, for example, we are obligated to ensure that this is written on a privacy notice available on our website. This will tell you what could happen with your data. You have the right for copies of your data. This is what's called subject access requests. You have the right to get your data corrected if you believe that your address is continually wrong in our system, then you have the right to ensure your address is corrected. However, this becomes more murky in instances like medical records where sometimes you may disagree with what your doctor has written. However, this is likely to be the doctor's assessment and therefore it cannot be changed. However, you still have the right to something entered on your records that you disagree with. You have the right to get your data deleted. Many companies will keep your data for much longer than they need to, in case they need it or want to sell it further. If they have not provided you with a reason why that data is being kept, you have the right to have that data deleted. You have the right to limit how organizations use your data. You may be happy for your data to be used in researches or used in clinical trials. You have a right to data portability. You have a right to have that data mirrored or copied into other areas if you so wish. You have a right to object to the use of your data in certain situations. You have a right to stop your personal data from being processed. You have a right to challenge decisions being made about you without human involvement. The commonest way to get this done, to give you an example, is if you are applying for a loan. You very often feed them a certain set of information which is entered into a computer which will measure how good your financial risks are to lend money to you. The computer will then come back to say yes you can have a loan or no you can't. This is known as automatic decision making. You have a right to access the information from a public body. This is a subject access request as we mentioned earlier. if your rights to raise a concern are reasonably obvious. A scenario. Here are some details about a footballer who has been rushed to hospital for surgery for an operation on a broken bone. A number of staff have spotted him on A&E and coming onto the ward, where they start looking him up on EPR. This is often very good-natured of these people who are concerned about their hero and want to see how well they are. However, what comes about is the staff discover the footballer has a history of severe depression. They then go home later and tell a friend about this. Eventually, the information ends up on Facebook, which leads to being reported in a local newspaper, and in one fell swoop we have outed someone's personal sensitive data. It's a very simple breach, however the information is detailed and demonstrates what went wrong. People are viewing a record they did not have a working requirement to do so. They were sharing confidential information about a patient. They were disclosing information in regards to a patient's past. And they were discussing this information on a public eye, Facebook. Coincidentally, please be aware that putting anything on Facebook is the same as going into a city square with a megaphone and shouting out for your private business. So what happens to you? Even without a complaint from a patient, we do monitor access to our systems. You could be found out. A disciplinary will occur, and the sanction could go up to including losing your job. If you're a nurse or a doctor in this particular instance, you would let your professional body be aware, which may result in you being prevented from working on your chosen profession again, or at least for a period of time. More importantly, if you've had information governance training and the trust systems are secure, which they are, then sadly you would be considered the responsible one and not the trust. So any fines levied by the Information Commissioner would not be levied against the trust but would be levied against you. Furthermore, in terms of the Data Protection Act, it now allows somebody in the footballer's position to go in for damages. In this situation, it would not be the trust, it would once again be you who were fined. You must be very careful because of a single incident you could see your whole job and savings go, as well as your reputation and potential to be employed again. In order to help prevent the kinds of breaches in confidentiality similar to those seen in the previous scenario, there are procedures to follow. Always remember, confidentiality is a legal requirement of your work for the trust. The trust is required to inform patients about how personal information relating to them will be used, inform patients of their right to object to the sharing of their personal information, get permission or consent from people before sharing their information for reasons that do not relate to their care. The Caldecott Principles. In 1997, Caldecott Guardians were appointed in each NHS trust in order to safeguard access to patient-identifiable information. They are responsible for ensuring that a trust and all employees adhere to the 7 Caldecott Principles when dealing with people's information. 1. Do you have a justified purpose for using this confidential information? 2. Are you using it because it is absolutely necessary to do so? 3. Are you using the minimum information required? For example, do you really need to supply their full name, date of birth and full address? 4. Are you allowing access to this information on a strict need-to-know basis only? 5. Do you understand your responsibility and duty with regards to keeping people's information secure and confidential? 6. Do you understand the law and are you complying with the law on data protection and security before handling the confidential information? 7. The duty to share information can be as important as the duty to protect patient confidentiality. It may be necessary to share information in order to keep people safe from harm. For example, safeguarding procedures for children and adults in these circumstances, we may have a duty to share the information. Listed here is how data protection principles apply to you. Firstly, data has to be processed lawfully, fairly, and transparently. Someone cannot use your data in a way that is illegal. If your data is lost or not stored correctly, this is a criminal act. Data can only be processed for specific purposes. If I tell you I'm recording data on your foot size for a piece of research on the size of men's feet, I will be in breach if I then sold it to Clerk's Shoes, who used that to send you specific advertising without at least telling you I was going to do so. We must use the minimum amount of data. If I only need to see you once and the reason why I'm seeing you doesn't need to be recorded, if I record that data, then I am processing more data than is required. I then continue to store your shoe size data for 10 years, from age 12 years to age 22, for regular appointments. I then recall you to have a new pair of shoes fitted. However, they are based on the size you had originally. I have not kept your data up to date. Your data must be secure at all times, or people who have not got a working requirement to access it may do so. Lastly, if we record your data, we become accountable for the processing of that data. So what can you do? If you need to talk to somebody about a confidential conversation, do not do it at a patient's bedside. Do not use other people's passwords. If you see a printed letter on the floor, pick it up to see what it is. If it contains confidential information, pass it on to your line manager or the manager of the area. You are never supposed to leave a computer screen on. If you've checked something and you walk away, log off. This is part of handling any patient or staff information with care. Always imagine the personal data is yours or that of a close family member. Be aware of policies. This applies to all types of records. Freedom of information. Sometimes the NCA gets requests for information called Freedom of Information (FOI) requests, such as: how many knee operations are performed? How many nurses do we employ? How many loaves of bread do we go through each week? But if the information requested is confidential or sensitive, for example, has Mr. Jones from Dobb Street, Oldham had a knee operation, we do not have to disclose it. The Trust has 20 working days to provide the information request via a Freedom of Information request. Record keeping. A health record is any record that contains information about your physical or mental health conditions and is made by or on behalf of a health professional involved with your care, whether on paper, a computer, digital, audio recording, etc. A good record is legible, complete, accurate, written contemporaneously, and easy to locate. The Record Management Code of Practice offers guidelines on all trust-held records. Commitment 8 of the NHS Care Record Guarantee promises patients that the NHS will take appropriate steps to make sure the personal information is accurate. To meet this commitment, we need to ensure that records are accurate. If somebody highlights that something we know about them is factually wrong, then we should alert colleagues to this. Up to date. Ask patients to confirm their detail as a matter of routine. Complete. Incomplete or inaccurate healthcare information can put patients at risk and may result in the wrong treatment or advice being given. Quick and easy to locate. We need to make sure that the records and information within them can be quickly located when required. Free from duplication. We may have to make duplicate records if we cannot find the originals. Written contemporaneously. Good record keeping requires that the information is recorded at the same time as the event has occurred or as soon as possible afterwards. The storing of records is very important. Penalties for the loss of personal data have increased incredibly since the new Data Protection Act has come into the law. Tracking systems are also vital, so that we know where the records are and where they need to be if they're out of their usual storage place. This should come as no surprise to anybody. Anybody who handles health records is responsibility of the safety of that record. That includes whether you carry them with you, whether you post them, or whether you destroy them. Finally, what should you do if you see any of the following incidents? Report it. If you see records left unattended, and you can without endangering another patient, please move them to a safe and secure place. Log off your computer screen. Ask staff to move if you feel empowered that you are able to do so. Pick up records and take them to the safest area possible. Do not supply information about patients. Always ask a stranger who is reporting to be a staff member to show you their name badge.